FELA versus workers' compensation. What is the difference? In this video, we'll discuss the differences between FELA versus workers' compensation, how injured railroad workers seek compensation, the requirements under FELA to prove negligence, how an experienced FELA attorney can help you, and much more. FELA, a federal law to protect workers in the railroad industry. Railroad employees injured on the job often face confusion when deciding whether their rights fall under Federal Employers' Liability Act claims or the protections provided by workers' compensation laws. While both systems are designed to support injured workers, the key differences between them can determine the scope of recovery and the process for pursuing it. Workers' compensation laws typically cover most employees under state courts and provide limited benefits such as medical expenses and partial wage replacement, regardless of fault. FELA covers railroad workers exclusively and requires proof of negligence attributable to the railroad employer, but it opens the door to full compensation for a wider range of damages. Unlike workers' comp, which is generally administrative, FELA claims proceed as lawsuits in state courts or federal courts, giving injured workers the right to a jury trial. This also means that defenses like contributory negligence may reduce but not eliminate recoverable damages. Because workers' compensation laws operate on a no-fault basis, compensation for pain and suffering is not available, whereas FELA covers non-economic damages as part of a broader recovery. The difference in scope can be critical. Where workers' comp may cap benefits, FELA allows for full compensation of lost earnings, medical expenses, and long-term impacts on quality of life. Understanding these distinctions helps railroad employees and their families recognize when FELA claims may be the stronger path compared to traditional workers' compensation. Can injured railroad workers file for state workers' compensation programs? Generally, no. Railroad employees are not part of the ordinary state-based workers' compensation programs that apply to most other industries. Instead, they are covered exclusively by FELA. The differences between FELA and workers' compensation explained. For most workers in the United States, on-the-job accidents are handled through the state-administered workers' compensation system. These programs were designed as no-fault alternatives to civil lawsuits, providing injured employees with medical coverage, a portion of lost wages, and limited death benefits without the need to prove employer negligence. But for railroad employees, the picture is very different. Congress passed the Federal Employers' Liability Act, FELA, in 1908. Recognizing that the dangerous nature of railroad use and operations required a more powerful form of protection. Because of this legislation, railroad workers are not entitled to recover under the typical workers' compensation system. FELA is the exclusive route for compensation after injuries sustained in connection with railroad employment. The two laws differ fundamentally in their structure and outcomes. Under state workers' compensation, injured employees may only collect a proportion of their lost wages and reimbursement for medical bills, and they are barred from suing their employer directly for personal injury damages. These systems do not account for pain and suffering, emotional trauma, or long-term loss of earning capacity. In other words, workers' compensation pays out benefits, but not all the costs of a serious injury are recoverable. FELA, on the other hand, specifically allows an injured employee to sue the railroad employer when negligence attributable to that employer, no matter how small in proportion, played a role in causing the accident. Section 51 of the statute makes this clear. Every common carrier by railroad shall be liable in damages to any person suffering injury while he is employed by such carrier, for such injury or death resulting in whole or in part from the negligence of any of the officers, agents, or employees of such carrier, or by reason of any defect or insufficiency due to its negligence in its equipment. 45 U.S.C. Section 51. This language illustrates two critical differences from workers' compensation. First, FELA is fault-based, meaning negligence must be shown. But second, the standard is exceptionally broad. Courts have consistently held that if negligence contributed, even in the slightest proportion to the injury sustained, the claim belongs before a jury. When does FELA apply? FELA's reach goes far beyond typical accidents. The statute allows claims for virtually any personal injury or death linked to railroad employment, including cumulative trauma and occupational illnesses. Some examples include train or yard accidents, collisions, derailments, or injuries sustained during switching and coupling operations, unsafe work conditions, broken equipment, inadequate lighting, lack of fall protection, or failure to follow a safety statute such as Federal Railroad Administration regulations. Repetitive stress and cumulative trauma, back injuries, joint damage, or other conditions developed over years of railroad use of unsafe practices or defective tools. Toxic exposure and cancer claims. Many injured employees bring FEL claims after long-term exposure to diesel exhaust, asbestos, silica dust, or other hazardous substances leading to cancers such as leukemia, lung cancer, or bladder cancer. Occupational hearing loss from prolonged exposure to excessive noise in rail yards or locomotive cabs. Workplace death. Families of railroad employees who suffered death as a result of negligence are entitled to bring FELA wrongful death actions. Each of these situations demonstrates FELA broader coverage compared to state systems. Where workers' compensation might only cover limited medical expenses and partial wage loss, FELA empowers injured employees or their families to pursue full compensation, including pain and suffering, loss of enjoyment of life, and diminished earning capacity. Why the distinction between workers' compensation and FELA matters. This distinction is not merely academic. It directly affects the outcomes for injured railroad employees. Because FELA is rooted in federal legislation, cases may be filed in either state courts or federal courts, giving workers more flexibility in where they pursue justice. Most importantly, unlike the workers' compensation system, FELA permits a jury of peers to determine damages rather than relying on a schedule of benefits. That means juries can account for the true cost of an accident, not just lost wages and medical bills, but also the toll of long-term pain, disability, or fatal injuries sustained through a railroad employer's negligence. Burden of proof in FELA claims. Under FEL, the worker must show negligence attributable to the railroad employer, but the statute sets a notably low threshold. Section 51 states that the railroad is liable for injuries or death resulting in whole or in part from its negligence. Courts interpret this to mean that if the employer's negligence contributed in any part, even the slightest proportion, the claim is valid for a jury. This featherweight standard makes FELA unique compared to ordinary personal injury litigation. Defenses often used by railroad companies. Unlike the workers' compensation system, where fault is irrelevant, railroads can raise defenses under FELA. The most common is contributory negligence, which reduces damages in proportion to the employee's share of fault but does not bar recovery. Section 53 codifies this. Damages shall be diminished by the jury in proportion to the amount of negligence attributable to such employee. Importantly, Section 54 abolishes the assumption of risk as a defense, and violations of a safety statute mean the worker's contributory negligence is disregarded. Recoverable damages under FELA. The scope of damages under FELA is far broader than under workers' compensation. Injured employees and their families may be entitled to medical expenses, full coverage for past and future treatment, not limited to schedules, lost wages and earning capacity, both wages missed during recovery and projected lifetime losses due to disability, loss of enjoyment of life, damages for diminished quality of life caused by the accident, occupational illness claims, including cancers linked to diesel exhaust, asbestos, silica, or other toxic exposures in railroad use. Recap: what are the main differences between FELA and workers' comp? Main differences between FELA and workers' comp include: 1. Coverage. Workers' comp applies broadly to employees in most industries under state laws, while FELA covers only railroad workers engaged in interstate commerce. 2. Fault. Workers' comp is no fault. FELA requires negligence by the railroad employer but applies a very low standard, in whole or in part. 3. Damages. Workers' comp pays medical expenses and a portion of lost wages, but excludes pain and suffering. FELA allows recovery for pain and suffering, lost wages, diminished earning capacity, and wrongful death damages. 4. Process. Workers' comp is handled administratively through state agencies. FELA is pursued as a civil lawsuit in state courts or federal courts, often with a jury trial. 5. Defenses. Workers' comp defenses are limited. Under FELA, contributory negligence may reduce damages, but assumption of risk is abolished by statute. 6. Jurisdiction. Workers' comp laws vary by state. FELA is uniform federal legislation applied nationwide. Gianaris trial lawyers, experienced FELA attorneys. At Gianaris Trial Lawyers, our team has built a reputation for handling complex railroad injury and wrongful death cases with precision, compassion, and relentless advocacy. If you or a loved one has suffered injuries sustained in railroad employment, don't settle for the limited protections of state-based workers' compensation. Trust a law firm with the skill and experience to fight for your rights under FELA. Contact Gianaris Trial Lawyers today for a free consultation and let us help you pursue justice and the compensation you are entitled to.